Hey everybody, News Now Wyoming, bringing another episode. Today we are going to look at the only interview Binger has given since his uh, trial of Kyle Rittenhouse. I have not actually heard it yet, so this will be as much fun for me as I hope it is for you. In the background, you can see a bunch of memes. I tried to focus only on Binger. Some Kraus ones did slip in, but uh, just so you know, that's about 2.5 minutes of memes. So if you want to actually see one that you miss, it goes by too quick. Don't worry, it'll come back again. So here we go. Let us go ahead and play this. Remember, you guys, I am going to be pausing this and talking throughout, and making commentary on this. And so if you don't like that, go to Miranda Warnings on Spotify and play this without me talking.
This week on Miranda Warnings, we're very pleased to have Thomas Binger, Kenosha County Assistant District Attorney and lead prosecutor in the case against Kyle Rittenhouse. Welcome, Thomas Binger.
Thanks, Dave. Thanks for having me.
It's really great to have you on Miranda Warnings talking about the Rittenhouse case that obviously had national attention. Just a brief background. Kyle Rittenhouse was accused of shooting 3 people with an AR-15 during the Black Lives Matter protest that took place in August of 2020, killing 2, wounding 1. And this all occurred in Kenosha, Wisconsin. During the trial, he was acquitted, claiming self-defense. Let me ask you, this is obviously a difficult prosecution from the start. What was your strategy going into this case?
Well, Kenosha is a community that is a small community, and we don't have these sorts of events happen. Most communities don't. But it's one in which we had a lot of personal experience where people felt the pain of what occurred in the evenings leading up to Rittenhouse shooting folks. It started with the shooting of a black man by a white police officer, which led to a lot of protests, which then turned into riots and arson and looting. And you had portions of our community that were deeply affected by that. Property owners that had their property damaged or destroyed, people who had to stay in for curfew, and it disrupted our community in many ways. The biggest concern I had about this trial was that there were a lot of people out there that felt that they would have done the same thing, that this is a hero, that this is someone who did what a lot of people didn't have the wherewithal to do on their own, which is to go out there and arm themselves and protect our community.
Okay, I just want to stop it here. I want to go back about 20 seconds, talk. The cops weren't protecting people. The cops weren't protecting property. The cops were actually pushing the citizens or the rioters away from the government buildings to protect the government buildings and pushing them towards the businesses. The only reason that they were there to burn the car lot or possibly burn the gas station, whatever, was because the cops pushed them away from where they actually wanted to be protesting, which was around the government buildings. The cops in the state failed to do their jobs. That cannot be stated enough.
So what I wanted to do as best I could during this trial was to try and differentiate this defendant from what people viewed as a young kid, the kid next door, my nephew, he looks like him, he's just doing what anybody would do, he's a hero. So if we view him that way, if we view him sympathetically, or if we think of him as my nephew or my kid next door, there's no way I'm going to get a conviction. And I think that there were a lot of things about this defendant that set him apart from the pack. And I filed motions before trial to introduce some of that evidence, such as his association with the Proud Boys, such as his
association with the Proud Boys. He went to a bar. Some people that he happen to be there, see him, they happen to be members of the Proud Boys. Is that really an association? Even during their pretrial motions, they provided no proof that other than that night, Kyle had any contact with them. Can they prove that he even knew who the Proud Boys were before he made a big deal out of it? So, association with the Proud Boys. Freaking
statement 15 days before the shootings that he wished he had his rifle so he could kill some shoplifters. And I wanted the jury to hear that information because I think if they had heard it, they might have seen him in a different light. Because I don't think those are the types of things that you hear a 17-year-old do. Unfortunately, the pretrial rulings went against me, and so we weren't able to get that evidence in front of the jury. And I think ultimately that made this case very challenging because he does present as a young, baby-faced kid who looks no different than your nephew or your next-door neighbor. You know, the kid that rakes your yard, the kid that mows your lawn or delivers your newspaper. And so it became hard at that point.
Yeah, he's a good kid, so it's hard for us to portray him as a not good kid. Makes sense. Thank you.
We had some less than sympathetic victims in this case who also had their so when you look at one side and you see the baby-faced kid, and on the other side you see some folks that have some baggage, that makes it even harder. In my mind, this really came down to a bright line distinction of, using deadly force in self-defense. And I continue to believe that, when you're armed and you're dealing with an unarmed person, you don't just get to kill them. And I argued strenuously for that with the jury. I think we had some good video that showed that this was instigated by the defendant pointing his gun in the first place, bringing it to...
He pointed the gun in the first place. This is that hocus pocus out of focus shot. And that has been debunked like 1,000 times. Some great people were doing that. He had to have been using his left hand to aim the gun. And then this hand would have been supporting it. And again, this is less than a second after he puts down the fire extinguisher with his left hand. Suddenly, he goes from that to aiming it. And then what they thought was the hand holding the end of the barrel turned out to be part of the car. It was there before any of that happened. It was a reflection on the car. Horrible, horrible evidence, but yeah, it's very clear evidence.
To a situation and confronting unarmed people, but the jury saw it differently, and that's the way things work out.
Yeah, there's a lot there, and since this is the Bar Association and lawyers show, that let's talk about some of the pretrial rulings that really went against your position. Judge Schroeder precluded the prosecution from calling those that were shot victims, but he permitted the defense to call those who were shot to be looters and arsonists. And as you just mentioned, precluded you from introducing or even referring to video of the defendant where he indicated that he, in a prior few days before, that he wished he had his automatic weapon so that he could fire a few rounds at looters, and also precluded you from referring to a potential association with an organization called the Proud Boys, white supremacists, yet permitted the defense to talk about, to identify one of the persons who was shot as an arsonist. So that really set the tone for where you could go. How do you think that affected the jury, especially the language you could use and your inability to go into the state of mind of Rittenhouse?
Yeah, it put the victims on trial. And, when you've got the ability to introduce evidence that portrays the victims as criminals, as arsonists, as, mentally ill, wanting to go back to jail, setting fires and doing.
These were all things Kyle saw and knew. at the time of the shooting. None of it was conjecture, none of that. But yeah, highly prejudicial.
Other things that contribute to the chaos. It puts those individuals in a situation where they're viewed as less than worthy. Their life is devalued, and we're limited in homicide trials. And I understand the general principle that we don't punish someone more severely if they kill a priest as opposed to killing a drug dealer. All life is sacred. So we're limited in terms of how much the state can put in good about the victim, and theoretically that should apply in reverse, that the defense should be limited in how much they can put in that's bad. What was problematic here was that the evidence that came in about one of these victims, Joseph Rosenbaum, pertained largely to the events of that night and why he was out there and what he was doing. So it was very close in time.
Yes.
It was in the moments leading up to all of this. And as I said earlier, I think that there are people in our community that felt like it was appropriate to go out there and shoot arsonists and looters and people who are starting fires and tearing down our community. And that's, I can see that reaction. It's not.
I have not seen anything from any serious person that says it's okay to shoot somebody over the burning of buildings. That is not what happened here. God, what a snake.
Unreasonable. I think if this is your community, your business, your neighborhood, and somebody's doing that, there are people out there that may reasonably feel that we need to take a stand against it. In my opinion, though, that way lays chaos. That way lays the breakdown of our society. We have law and order, we have the rule of law, we have law enforcement to govern these sorts of things. You want to go back to Dodge City in the Old West, that's one path, I guess. But at the end of the day in this trial, I said it when the jury came back, the judge entered the judgment of conviction, and I said the jury represents our community, and they've spoken. And in a sense, I think they've said that, at least under these circumstances, they're okay with this behavior. I stood against it. I don't believe in it. I draw that line, and I think that we can't tolerate it. But for whatever reason, the jury and certainly a large portion of our community feels differently. It's my sincere hope that this doesn't lead to copycats. It doesn't lead to others taking these matters into their own hands and trying to justify this.
Wow. He hopes that this doesn't lead to others making the same decisions. So he's hoping somebody prefers to be beaten to death on the side of the road instead of shooting somebody dead to protect himself. Is that what precedent he thinks is set here? Really confused by what he doesn't want to have happen.
This type of behavior, because, like I said, that way lays chaos, and we can't have that.
Yeah, the interesting and difficult part of this self-defense is this wasn't an individual that was at his home, that was defending his home from an intruder or even rioters. This is someone that drove across state lines with an automatic weapon. I'm not sure of the exact purpose. Maybe you can talk about that. But when all this occurred, he was just walking through the streets. He wasn't necessarily
chaos, and we can't have that.
I want to hear that again.
Yeah, the interesting and difficult part of this self-defense is this wasn't an individual that was at his home, that was defending his home from an intruder or even rioters. This is someone that drove across state lines with an automatic weapon. I'm not sure of the exact purpose.
Why is this still the freaking narrative? The AR never left Wisconsin. The AR was there. Why is the argument he drove across state lines with a weapon with the purpose of killing somebody? Why is that the narrative? I will be curious to know if Binger stops him and says, no, he didn't cross the border with this. Now, it is also very important to note that he crossed state lines, but this was his community. We're talking a 15-minute drive. One of his victims, Gage, drove 90 miles to get there. All right? He drove 90 miles to get there, but Kyle's the interloper. Because he's from a different state, so he shouldn't care what happens here. Even though he was part of that community. He had family in that community. He had just the stupidity and the ridiculousness of that argument of he crossed state lines. Let's ignore the weapons. He crossed state lines with the weapon. False. Very false narrative, but he crossed state lines. He crossed state lines from the community just across the border. Nobody called out the fact that when he said, other than Kenosha, the nearest police station was my own police station in my hometown. Nobody said, well, no, there's a police station here in Wisconsin that was closer. Why didn't you go there? Nobody called him out on that because it's true. The closest community to Kenosha was Kyle's hometown. And I liken it, I live here in Wyoming, so I think of all of our rural towns around here. And then we've got some of our larger cities and stuff, or somebody coming across the Nebraska border, just on the other side of the border, to come to Cheyenne. And they do that multiple times a week. That is their community. Such a baseless, horrible narrative, and people just keep repeating it, especially about the gun, crossing over the border with his gun. Is Binger going correction on it? I haven't heard yet, so let's find out.
Maybe you can talk about that, but when all this occurred, he was just walking through the streets. He wasn't necessarily defending anything. And so
false.
Isn't
he wasn't protecting anything. No, he was not just walking down the street. Did this guy even watch any of the freaking trial? Okay. Binger, set him straight. Tell him the truth. This is your chance to redeem yourself in my eyes. Wow. Yeah. Hold on, you guys. I think. Okay.
Isn't that different than you trying to defend your home or your property than just walking through the streets with an automatic weapon? Can't you expect that there's going to be trouble?
Well, that's the argument I made. I do want to clear up one little misconception out there, Dave, that you just mentioned, and I hear this from a lot of people. There's a belief out there that he crossed state lines with the gun, and that actually is not true.
Thank you.
This is a weapon that never left the state of Wisconsin. It was bought in
Good.
a small town in Wisconsin. It was kept at his friend's residence in Kenosha, and when he came up that day, he did get it from his friend's residence. But more to your point, you're right. This is an individual who doesn't have any ties to the community, who takes it upon himself to arm himself and come down to a business he's never heard of before, whose owners don't even care enough to be there. They've emptied out the place. There's nothing left to protect except for four walls. And one of the things I tried to argue to the jury is this is an area of town where we've got a daycare, we've got multiple churches, we've got small businesses, we've got a school, and he's going to protect a used car lot. No offense to used car lots, they serve a valuable purpose, but really if you're really concerned about the community, that might have been like the 6th or 7th highest priority location in that area. But it's not his home. It's not a place he worked. There was no one inside. No one's living there. There's no property left really to be damaged. And I think we're dancing around the real point here, which is that this is a kid who had his own agenda. And this is the point of the trial that we couldn't get to because the judge wouldn't allow us to. But this is a kid who had his own beliefs, who had his own agenda, who wanted to make a point, and he was clearly on, to simplify things, on one side of the public debate here. And I'm not trying to criticize or defend or whatever either side. Everybody's entitled to their opinions, but let's not hide the fact that he was there because of those beliefs, and he was there to strike a blow for those beliefs.
Is this suggesting that he went there to kill people? Or... because you didn't even try to introduce that type of evidence.
And it became this veiled subtone in the trial of these looters, these arsonists, these Black Lives Matters need to be stopped. They deserve to be killed because of what they're doing to our community.
Nobody said that.
And it goes back to the point we talked about earlier, which is we should be allowed then to give the other side of the story, which is this is someone who's associating with Proud Boys. This is someone who uses that gun in unreasonable circumstances, and there's an agenda here. So we hear one side, but we weren't allowed to hear the other side, and that's unfortunate.
Yeah, so let me dig a little deeper there, because I know you tried very hard to paint that picture, and quite honestly, just from an observer's point of view, watching it on TV, it seemed as though the judge was very critical of some of your approaches. And as far as I can tell, most of that criticism came outside the presence of the jury, but nevertheless seemed very critical. There were a couple of issues that I just want to talk about. There was one, we talked about this video of Rittenhouse saying he wanted to shoot looters on a previous day. And apparently, obviously, that didn't come in, but you made reference to it during the testimony, and the judge was very upset with that, making reference to it, and he said that he had ruled on that issue already, and you had indicated that perhaps he hadn't ruled on that issue and that it was an open question. What happened there?
So first of all, I think your audience of attorneys will understand what I'm saying when I say that Judge Schrader is a judge who barks, and we've all dealt with judges like that. For those who don't know him, a lot of my non-attorney friends have been shocked at some of his behavior, but honestly, it's par for the course with him. Off the bench, he is one of the nicest human beings you could ever meet. But when he puts the robe on, like some judges, he changes. And I've been in his court. I've been yelled at before. It really goes in one ear out the other. So that was not unusual for being in that courtroom. So that's why I didn't really react to it, because I've heard it all before. To your point about that legal issue, what the judge had done at the motion hearing prior to trial was he had indicated that he was inclined to not allow that evidence in, but he would leave the door open based on the evidence at trial. And this is something he's done in other trials that I've had. A lot of judges like to make a decision on other acts evidence, what we call here in Wisconsin other acts evidence, Rule 404 evidence in the federal rules, long before trial, so that everybody knows the rules going in. This judge has always made it clear that he will reserve those rulings and kind of see how things go at trial. And so as the evidence comes in and it changes throughout the trial, it affects how he rules on things. And so I was expecting that that would be his attitude here. He made it clear the door was still slightly open. He hadn't completely closed it on this evidence. And when there was testimony from the defendant that I felt was opening the door and allowing this evidence in that was pertaining to it, I felt that it was appropriate to go there. I think his biggest issue was that he felt I should have raised that with him ahead of time. But of course, I'm in the middle of cross-examination. I can't just pause and say, Judge, I need a 5-minute recess so I can ask you whether or not I can go down this line of questioning.
Bull, that's exactly what you do. Remember, you guys, he is talking to the New York State Bar Association president. And everybody that typically listens to this show is an attorney. And we'll talk about some of these other podcasts on here. I've never heard of Miranda Warnings. I do want to listen to some more stuff, but what I'm seeing here is a lot of the left-leaning BS. But he is talking mainly to lawyers. That's who the audience of this podcast is attorneys. Every single one of them know that before you raise an issue in front of the jury, that the judge has already said, yeah, no, you shouldn't do this, then you raise it outside the presence of the jury. And most particular about this case is that very morning, the judge ruled that none of his prior rulings, including this one was asked about specifically, that none of his prior rulings, nothing he's seen has changed his mind on any of it. So Binger cannot, on his own, make that call. But he's going to downplay it here.
Questioning. And I think it can't be overemphasized that we're talking about a cross-examination in a double homicide case. I'm sorry, but there's a lot of leeway in that type of situation.
No, there's
this
not.
Is a defendant who's taking the stand and is testifying about 2 killings that he committed. I'm entitled to a little leeway here. You know, this isn't something where I brought in a third witness to talk about this video, something like that. I didn't put it in my case in chief at all. But now we're on cross. Now he's taking the stand. Now he's got to answer. And I think in those certain situations, I think courts should allow us quite a bit of leeway. And unfortunately, he didn't. But again, the verbiage, the words he used, the way he addressed me, it really is par for the course.
So you've been before Judge Schroeder before.
So I've done trials with him, and I did trials with him over 10 years ago. I was in his court on a regular basis for over 2 years in our office. I think this is my 3rd homicide trial with him. So I've done quite a few trials in front of him, and I'm used to him. Our entire office is very familiar with him. He's a judge, like I said, who's got a lot of bark. Oftentimes his bark is worse than his bite, like is true for a lot of judges. But you have to have thick skin in there, and you have to understand that there are times when he's going to use you as an example for whatever he's upset about. There are judges who have different demeanors, as we all know, and some of their demeanors are more pleasant than others. And like I said, off the bench, he's an absolute prince. But in his courtroom, you have to be prepared to take a licking every once in a while. And like I said, been there before, used to it. Didn't really affect me too much.
So watching him, this is the first time, obviously, I've become familiar with him, and many people. Would you say, since you've been before him before, did he act typically? Did he act the same as he would have in other cases, or was there a difference in how he conducted himself because of this case?
I think the country got a pretty full and accurate picture of Judge Schroeder. He's got a lot of his own little peccadillos, the Jeopardy questions during jury selection, the ringtone and answering his phone in the middle of trials, the very learned treatises on the founders and on ancient history. He's an incredibly intelligent man, and he is our longest serving judge currently in the state of Wisconsin. He's been a judge for I think 37 or 38 years now. And boy, I hope I'm half as sharp as he is at that age, because he's still, very mentally agile, very adroit on the law, very learned. But you have to understand that there are those little peccadillos, like any judge, and some judges have stronger and more obvious ones than others, and his are quite pronounced. But no, I think that was largely an accurate picture of what
a very political answer here. He knows he's going to have to go in front of this judge again. In fact, he's already been in front of this judge again with Kyle's friend. So he's got to be really politically correct here. He's kind of said, well, he's kind of a dick. You saw that, but he's not crossing that line.
Things are like in his courtroom on a regular basis.
So, obviously in a trial like this, you're bound by what the charges are and what, your office decided to prosecute. They were all, it was first-degree reckless homicide, and obviously the issue came here as to whether there was self-defense. And in Wisconsin, when self-defense is raised, the burden is on you as the prosecutor to show beyond a reasonable doubt that it wasn't self-defense. Obviously, very difficult standard. But I want to ask you about, why wasn't there? Wisconsin has a second-degree homicide where you could have charged second-degree homicide with the position that the defendant thought he was entitled to use self-defense, but his use of force was unreasonable. Why wasn't the second-degree homicide brought?
So There are different charges for the two homicides here. The first killing was of Joseph Rosenbaum. That was charged as a first-degree reckless homicide. The second-degree intentional homicide would not have been a lesser included on that offense. It's kind of a different line of creation of.
So you would have had to make a choice to go with one or the other.
Right, and with that particular incident, we considered that a reckless homicide in the sense that it was not something that we felt we could prove premeditation on. It was more of a hurried, chaotic response on the defendant's part. So we felt that that was better characterized as reckless. To your point of second-degree intentional homicide, you're right. That is a lesser included of first degree. And that would have applied to the second killing of Anthony Huber, who had the skateboard. That was originally charged as first-degree intentional. In the jury instruction conference with the judge, we persuaded him to allow the jury to consider the second-degree intentional homicide as a lesser included charge. To begin the case with that second-degree intentional homicide, I think would have given up too much ground, because I think
I agree with them.
First-degree intentional homicide is obviously a stronger charge. It carries with it a mandatory life in prison. I think it's the appropriate charge here, and I think it better crystallizes the real issue here, which is I'm not sure that I believe the defendant when he says that he had a genuine belief that he had to defend his life in that situation. I think that there's credible evidence that suggests that he.
Mr. Binger, have you ever heard of a case where somebody died from getting beat in the head with a skateboard or other blunt object? Have you ever seen a case where somebody died from getting beat in the head with his fist or with his feet? Have you ever seen anything like that in all of your years of experience? Have you ever seen or heard of that type of thing happening? He is on the ground being attacked after being hit in the head twice.
He was out there essentially looking for trouble, bringing a gun into a violent situation to escalate, having his own political agenda. And so I think that he was willing to kill that night going in and willing to accept that. So I think there's some element of no matter what was going on around him, this was.
Here's my problem with Gage's testimony. He said he was carrying his gun, but he would have never been able to pull that trigger on anybody. I carry my gun every day. No, I don't, you guys. It fell in the lake. But if I had a gun, I would carry it all the time. And you better believe that if I feel that I am threatened of death or bodily harm, I'm going to use it. There's no other reason to ever carry one. None. No reason at all other than that. If you do not feel you can use it, then you pose more of a danger having it to the people around you and to yourself than if you didn't have it with you.
Was potentially going to happen. So that goes to the genuineness of his beliefs here, where I don't buy his testimony that he sincerely believed that he needed to do this to preserve his life. Now that's what he testified to, and if you believe that, then the second-degree intentional homicide asks the jury to decide whether or not a reasonable person would have felt the same way in his situation, which is sort of the objective standard of it. And I don't see any reason why any reasonable person would put themselves in that situation or believe that, but obviously the jury concluded otherwise. So that was their verdict of not guilty on that. But to your question, I think charging it initially as second-degree intentional homicide, I think would have given up too much. And I think it in my opinion, didn't fit the facts. I wanted the jury to consider that because I was concerned that if they didn't buy the first-degree intentional homicide, they potentially just let him walk without considering any lessers. And I wanted to get a conviction out of this if I could, because I think there's a message that's sent here. This is a case where everybody's taking some sort of meaning from it, right? Lots of people out there have taken it to say he's justified, he's right, he's innocent, he's a hero, and we should all be doing what.
I do not think Kyle is a hero. I think he did something that nobody, so many people that lived in Kenosha, they weren't going to do. Okay, he is not a hero. God, and I doubt he wants to. He wishes that this day never happened. He is not a hero. I do not look at him that way. He is also not the devil.
He did. And that's unfortunate. And I wanted a different message to be taken from this, because I continue to believe that this is the sort of behavior we cannot condone. There has to be a consequence for it. And it's too dangerous to allow this. We're not alone. New York's had its own types of situations. Seattle, Portland, Washington, D.C., lots of communities around the country. Minneapolis have seen protests and violence that has spilled over into looting, arson, and other criminal activity. And I've prosecuted, and I'm continuing to prosecute people who committed those violent acts during this incident. So I get emails from people saying, "Why aren't you going after the looters or the arsonists?" Thanks, I am. I have several of those cases on my caseload, and so does everybody else in our office. But you have to have the police investigate. You have to have the police arrest. You have to have the police prosecute. You can't go out there and do vigilante justice. Then you don't leave me anybody to prosecute. I mean, if Joseph Rosenbaum had not been killed that night, and I had all the video and photos that we wound up having, I would have charged him with arson, and I would have taken him to trial and hopefully convicted him, and maybe he would have gone to prison for committing arson. But he wouldn't have been killed. We don't kill people for arson.
Right, and I think you made the point during the trial that the first person that was shot, Rosenbaum, wasn't a good actor. That he did these things that were criminal. But as you just said here, we have a process for dealing with that, and the process is not executing them on the street by someone who's not in law enforcement, someone that has no training and no experience, and is just walking around with an AR-15.
Yeah, but he believed he did. And that's another factor here that goes to his subjective belief in the sincerity of it. This is a kid who claims to have been in some sort of youth cadet police program in Illinois, had worked with some local fire department or something. I mean, I think he had notions or delusions of grandeur that he'd gotten some imprimatur from the local police to go out there and do what he wanted to do, and they approved of it. And so he took the law into his own hands. And that's certainly not something we want anybody to do, but a 17-year-old kid, it's unfortunate. Two people lost their lives and didn't have to.
And let's talk about Kyle Rittenhouse specifically. He took the stand in his own defense. What's your assessment of how he did, and what impact that had on the trial?
I've never in my life, and I've done over 100 jury trials. Not all defendants testify, obviously, but I've never seen a defendant testify and then be cross-examined and there's no redirect. They got him off the stand as quickly as they could, because they knew this is a kid who they can only fill his head with so much coaching, and then it's going to break down. And after 5 or 6 hours on the stand, it's not going to last. So they had a calculate.
No, it happened because you did not do a good job crossing him. You didn't ruin their case. You screwed up. You missed. But no, it's because they're scared.
Play a strategy here. They spent months, I'm sure, and money and time with whoever's out there helping to prep him for trial. And I think on his direct examination, I think he did a nice job. He did what they asked him to do. He came across. He looked presentable. He told his side of the story. He had his day in court. There was a time in which he started breaking down and crying, which I thought was unconvincing. I thought that it was...
It looked exactly the same as when he got the not guilty verdict. Anybody that can look at that, those two together and say this was fake, you're stupid. Yes, I'm going to say it. You are absolutely stupid. You are blind, not sincere, my ass.
prompted by his own selfish fear, or what he claimed to be his fear at that time, which I think is a less than sympathetic prompt for crying. I think the tears were manufactured crocodile tears, and I think the jury saw right through them. And there was no remorse for anything. He was unapologetic, no concern about the lives that he took, none of that. And I get it. You got to walk a fine line in a self-defense case. You can't be saying I'm legally justified, but I feel bad that I killed those people. So, I get that.
He did say that. That's exactly what he said. He said he didn't want to kill them. He said he felt sorry for it. He said it multiple times how remorseful he was. You can't watch his testimony and say he was unremorseful. You slime bag.
On cross, I did my best. I don't take a ton amount of pride in it. I think I could have done better.
Yes.
I tried my best to knock some holes in it. I think that I view cross-examination as if you had a block of marble in front of you and you've got to sculpt something. You can't take a sledgehammer and hit it in the middle and crack it in half. You got to go at it from the sides. You got to chip away inch by inch, part by part, and eventually you get something that you're looking for here. So I tried to chip away where I could at portions of this story that didn't make sense. And I think that I got him to admit some important things. One of the parts of this case that was always going to be a concern was before the defendant shot and killed Joseph Rosenbaum, there was a gunshot that went off about 2.5 seconds before that in that very same area. It was shot off by a third party by the name of Joshua Zeminski, who was tangentially related to the case throughout. And in their opening statements, there was some emphasis on this, that Rittenhouse felt, that shot was a danger to him. He heard it from behind him, so he's turning and reacting. And, for all I know, it's coming from this guy who's chasing me, and now I got to kill him because I think he's got a gun. And that was a concern I had, was they were going to lean heavily into that. I'm prosecuting Joshua Zeminski for arson. I got a trial against him at the end of January. I think he's a knucklehead. I have no idea why he fired that single shot off. Certainly didn't help situation. So I was very concerned about what they were going to use that to try and justify the self-defense. But what I got Mr. Rittenhouse to admit on the witness stand is that shot had nothing to do with any of this. He didn't pay any attention to it. He didn't think it came from Rosenbaum, didn't think it had anything to do with anything, which I thought was an important concession, because now we're clearly just talking about an unarmed man who's chasing after you. And Rosenbaum...
An unarmed man, and he should have just taken the beating. Everybody takes a beating. I know that was Krause that said it, but everybody just takes a beating sometimes.
Jumps in the air with his hands up in the midst of all this. So it's clear that this is an unarmed person. And I know some states like Florida have stand your ground laws where anybody who comes at you, you get to kill them, but not in Wisconsin. And
it's not the law in Florida
I equated
either.
it in my closing to a bar fight. Unfortunately, we got a lot of bars in Wisconsin. We like our beer, and there's bar fights, right? Two unarmed guys, they're throwing punches or whatever. Well, God forbid, the next bar fight, some drunk idiot comes at you, pushes you, shoves you, takes a swing at you, and now I get to pull out my semi-automatic pistol and kill him in cold blood. I mean, that's essentially what was going on here. And
that is not what was going on here.
Okay.
It was a stupid argument then. It's a stupid argument now.
Be a tragedy if that's the message people take from this.
Right, and I think there was some testimony from others that saw this Rosenbaum operating before that he, appeared obviously a little bit off, and others were just avoiding him. They, walked the other way, and that kind of diffused it. And Rittenhouse obviously chose not to.
He tried! What the fuck are you talking about, you stupid ass?
That was the difference. Now, you said something before that I know trial lawyers, we always beat ourselves up. We're probably our worst critics internally. But you said you thought you could have done some things better. Now, with the little bit benefit of hindsight now, is there something that you're thinking maybe you could have gone into? I know it's a tightrope. You don't want to push too hard because you don't know what kind of answer you're going to get. But what do you think? What are you thinking that you could have done a little differently?
One of the things that I was on the fence about at that particular moment in time was how deeply I wanted to go into the photos and the videos of the actual shootings themselves. I had heard from others that when I had previously played video of Gage Grosskreutz, for example, with his arm nearly blown off, when I played video of Joseph Rosenbaum gasping out his last breaths, that the defendant looked away. He was uncomfortable seeing the fruits of his labor. And I considered whether on the witness.
So you know this, but you don't believe he feels bad about it? You don't think he feels remorse for it? Slimeball, slimeball, slimeball.
Stand, I would confront him with that and make him look at his victims, make him look at what he had wrought, and own it. You know, you're here telling us that you were right, that these people deserve to die. Well, here they are. Now look them in the eye, unflinching, and own what you did. And if you can't, if you're nervous, you're scared, you're grossed out, you can't confront that, I think that says something about your conscience.
Yes.
I think that says something about your beliefs here. And I think if you are not man enough to own up to what you did, then don't you dare come in here and tell us that these.
I'm former military. I know a lot of veterans. I know a lot of veterans that were in combat. I never was. But I know a lot of veterans that were. And how many of them do you think want to see the results of their kills? Their kills were righteous, right? Were probably righteous, we should say. I mean, depending on how you feel and all that crap. But at the end of the day, their kills were righteous. But how many of them want to look those deaths in the eye? What a slimeball. He was a 17-year-old kid that killed 2 people and shot a third. He felt remorse, and you could tell he felt remorse. And you think he's guilty because he can't look at these photos? That makes him guilty? The only thing that it says about him is he does have a conscience about it. He does feel sorry for it.
These people deserve to die, and you're legally justified in doing all of this. So I considered that, and I thought about playing it for him and making him confront that reality. I ultimately decided against it, much like you just said, because we don't know. And I was concerned that I would give him an opening to look sympathetic. He would cry, he would blubber, he would, give some sort of sob story, and it would feed into the narrative. So I decided against that. But it was a difficult decision, and maybe if I had, it would have made a difference. I don't know. It's hard to say. But it's rare to do a trial where the murderer takes the stand and says, yes, I did it, but I had to, and I'm right. And there's rarely 2 sides to a murder trial. There's rarely a side that says, oh yeah, that guy was right to kill those people. It's always, I didn't kill them, or I wasn't there, I have an alibi, or it was someone else. It's always trying to dodge the actual crime. Here we had him embracing it. It's like, yeah, it's me, I did it, absolutely, blah blah blah. So you don't have that other side of it. And in a different trial where you've got a defendant who's not admitting they did it, who's claiming they're someplace else, playing the photos or videos of the murder, it doesn't resonate, because they're saying, hey, I wasn't even there, so I don't. Right. This doesn't have any impact on me. So it was an unusual situation that I haven't really encountered before, where you've got somebody who's owning up to it, and so I thought about making him confront all that and seeing it face to face. So maybe that would have made a difference. Who knows? It's hard to say.
And I guess as a prosecution, you have to balance that. You don't want to appear, mean or insensitive, that you're, pushing the most salacious parts of what happened. And obviously, if you're putting in front of him, you're putting in front of the jury, and you might make you appear.
You're exploiting the victims. You're cheapening it. So there's those factors as well. And I'm dealing with victims who have families. They're there and I've got an obligation to them as well. So I was concerned about that too. That's an absolutely an excellent point, Dave.
Have you had a chance to talk to the families at all since?
I have not. A couple of the families were largely participating by essentially by Zoom or remotely. We had Mr. Huber's closest. The person in his family that he was closest to was his great aunt who testified, and I didn't get a chance to talk to her afterwards, but I know other folks in our office did. And then Mr. Grosskreutz and his attorneys, we've had a little bit of communication.
Okay, I understand he's a government employee, but he can't take 10 minutes out of his day to call the families, say, sorry, I screwed this up for you. I disagree with the verdict, but it is what it is. You can't take 10 minutes out of your day for that? Out of your evening? Can you take any time out for that? I mean, that's just common decency.
Since then, but not me personally.
You made another strategic decision during the trial. You characterized Rittenhouse as what you called an active shooter, and you used that term, active shooter. What was the thought process that went into using that? And the question I have is, by using that term, did you perhaps set the bar too high that now you had to show that this person was an active shooter when maybe that wasn't necessary?
And Dave, I think I probably didn't communicate that notion very well, because you've characterized what I said in a way that others have too, and it's clearly that I didn't make this distinction very very well at the trial, because I wasn't actually trying to say myself that he was an active shooter, but what I was trying to say is that from the crowd's perspective, that's how they viewed him. And that was a reasonable assumption on their part.
It doesn't matter how the crowd views him, it's what Kyle thinks at the time. It's the only thing that matters. Now, if you were trying Gage for attempting to murder Kyle, then it depends on what Gage is thinking at that moment. That's the only way it matters.
At that particular moment. I don't necessarily believe that he was going to go and mow down 25 people or anything like that. But what I was trying to say is that after learning that he just shot someone, seeing him running through a crowded area with a gun, that it would have been reasonable for the for the crowd to view him as an active shooter.
Not
and under
important.
those circumstances, we have in Wisconsin, we now have the ability for individuals to apply for a permit to carry a concealed weapon. I have one of those permits myself. I'm a gun owner, and we are allowed to carry concealed weapons in public. And one of the rationales behind that is if there's an active shooter, if I go to the grocery store and somebody pulls out a gun and starts mowing people down, well, then I've got my gun and I can try and stop them. And I'm using I generally there. I don't have any intent of doing that myself, but a lot of people out there think that that's what they
No need to save innocent lives.
And the larger question that I have is, when
Ruin
the
them
police
instead.
arrive and they see two people with guns who are both shooting at one another, how are they supposed to know? How are they supposed to know who's right and who's wrong? How are they supposed to know that one person's got the right to self-defense and the other one doesn't? And getting it back to this case here, Rittenhouse wants us to believe that he had to defend himself against Joseph Rosenbaum. Well, that's in its own little category, and that's an event that's happened, and we don't have a judge and jury there to make that decision at that particular moment in time. All they know, all the crowd knows, is he just shot someone, and now he's running with his gun. And it's reasonable for them to assume at that point that this is someone who may be running to his next victim. We simply don't know. And in my mind, if someone in that crowd had a gun and had shot and killed Kyle Rittenhouse, our office would not have prosecuted. Our office would have not found that person criminally liable. Now, would there have been civil liability? I'm not an expert, I don't know. But would I say that that's justified self-defense for someone in that crowd to stop an active shooter? Yes, I would say so. Now here, this crowd didn't take lethal action against him. They actually used what I would characterize as probably the least intrusive means.
Yes, hitting somebody in the head with a skateboard is the least intrusive means
Possible. I mean, they try and hit him with a skateboard. They, try and knock him to the ground and kick him in the face when they could be doing far worse to him. But my argument on that.
They couldn't do far worse than him because he shot anybody that tried. Or he shot at anybody who tried. What would have happened if he hadn't shot Huber? What would have happened if he hadn't shot at Jump Kick Man? Do you know? No, neither do I. But I'm glad I don't have to find out. Because he would have been a dead 17-year-old boy. I am certain of that.
That point was, it really comes down to who's got the right to self-defense in that situation.
Everybody.
In the end of this entire encounter, you've got the defendant on the ground and you've got Gage Grosskreutz standing over him with a Glock pistol in his hand. The defendant has an AR-15 and they're 2 feet apart. Now, is it possible?
Everybody in this circumstance has the right to self-defense. Everybody would have been reasonable in their beliefs. That is not the question. The question is, was Kyle reasonable in believing a fear of deadly harm or great bodily harm? Did he have a reasonable belief to believe that? Yes, he did. Nobody else matters. Kyle's thoughts are the only ones that matter. You slimeball prosecutor.
That both of those people at that exact moment in time have an equal right to self-defense.
Yes.
I don't think so. I don't think there is a situation. I think in any situation, someone's got a greater right.
No.
And so who's got the greater right?
It's not the way the law reads.
Kyle Rittenhouse, who's just killed 2 people and shot at a third, and this has all happened right in front of Gage Grosskreutz, or Gage Grosskreutz, who's done nothing wrong at that point. And unfortunately, the way our jury instructions are worded, we're not allowed to look at it as clearly from the perspective of the victim.
Because it doesn't matter.
What I tried to argue is Gage Grosskreutz and the rest of that crowd have a greater right to self-defense than the defendant. And so if they view him as...
Having a greater right does not mean he doesn't have a right. Having a greater right of one person doesn't mean that Kyle's beliefs for himself were unreasonable. You slimeball, disbarbinger.
As an active shooter, if they have no definitive answer on who was right or who was wrong in that first shooting, I think they've got the right to take steps to disarm, to neutralize, and perhaps even to kill someone that they perceive to be an active shooter. And so that's the line of argument that I was trying to make to the jury. And I think this is a situation that we have seen before, from Columbine to Sandy Hook to the Aurora, movie theater. There was a situation a few years ago, I think it was in Denver somewhere, where a police officer showed up to an active shooting and inadvertently killed the guy who was innocently trying to use his gun to stop the active shooter. It was that situation I described earlier with the grocery store. They killed the wrong guy. You don't know in an active shooter situation. And a couple of the officers in the trial testified. First rule is neutralize the threat. We're not here to treat the wounded. We're here to stop the threat. That's our number one priority. And so that was my argument, is this crowd has the right to stop the threat. They have the right to defend themselves, and he loses it at that point. You can't have 2 people with an equal...
Why does he lose it? Where does it say that in the law? Show me in the law where it says he loses it because somebody else felt differently. Where does it say that in the law? Where does it say that in the case law? Now here in New York, where again this interview is happening, is with the New York State Bar Association. New York wacky stuff, so I wouldn't put it past them.
Right of self-defense. Theirs has to be greater than his. And that's something I think the jury should have considered. And if they agreed with me on that, then I think he should have been found guilty. Obviously, they saw it differently.
What do you think was the turning point here? I mean, you mentioned Gage. I mean, gross Grosskreutz.
Grosskreutz, yep.
Um, he was the individual that was shot but wounded, and actually testified. Um, there's some feeling that some of his testimony actually helped the Rittenhouse self-defense, because he said
Yes.
he never raised his gun to him until this individual went to try to take it away from him, which is certainly not unreasonable when the person already shot somebody. But that testimony was appears to be particularly crucial as to showing the mindset of Rittenhouse.
Wow, what a horrible paraphrasing of what happened. What happened, for those of you that did not watch this golden moment, oh my God, this golden cross-examination. Law schools across the nation should be showing this, of this is how a cross-examination should happen. But, so this golden moment, let's talk about this. Oh my gosh, how amazing this, the lights all turned on, right, over the defense attorney. So Gage is on the stand and he's testifying, and slowly, he doesn't want to get there right away, so the defense attorney has to slowly get there. But finally he asks, is it true that he did not point, or he did not pull the trigger until you pointed the gun at his head? Correct. So the gun is his gun is in the air. He's like, not shooting, not shooting, not shooting. Bam! I'm shot. I don't know why I'm shot. Why he shouldn't feel the need to shoot me because I pointed my gun at his head. Yes, that was a very golden moment. And of all the other cases, I thought maybe they might get a conviction on some of the others, but I knew at that moment, with Gage saying that key moment, there's no way you can find it unreasonable for Kyle to fear for his life when he did not shoot when the guy had his hands in surrender, but he does shoot as soon as that gun is pointed at his head. And Gage admitted it. Key moment for the defense.
What was your thought on putting this individual on the stand, and how his testimony impacted the case?
Honestly, I considered not even calling him at all. In fact, I talked to him and his attorneys before the trial, and I told them I was on the fence as to whether or not to put him on the stand because I was concerned that he did more harm than good. And
he did.
I think we were handed a situation here where we didn't have the most sympathetic victims in the world. And I think Gage Grosskreutz has got a lot of positive qualities. He's trained as a medic. He's out there trying to help people. I've met with him several times. I like.
He didn't have his supplies on him. He wasn't. Never mind.
Like him personally, but there are some things in his testimony that I knew were gonna come back to hurt us. He's involved in a civil lawsuit against the city. He's associated with some protest group out there that has a particularly, a name that just doesn't resonate well with our community. People's Revolution or something like that. It sounds like Chairman Mao, and it's just not a good look. So there was some of that, but I felt in the end the jury needed to hear from the victim. He's a victim on a criminal count. We've got to present his testimony. They need.
Yeah, I agree with him. They had to present him. They should have done a much better job with prep, but they had to. You guys, he is the only at that moment known living victim remain. Jump kick man, they knew who he was, but they didn't. I mean, big ol' mess with that. But
need to hear from him. And that was kind of my attitude throughout a lot of these witnesses, is I was trying to put all my cards on the table. I'm not hiding anything. I want the jury to hear everything, good and bad, and ultimately.
Then why didn't they hear it from you? Why did the defense have to get it out? If you wanted the cards on the table, That would have come out in cross, in a direct examination, not in cross. If it would have come from you, it would not have been a golden halo moment for the defense.
It comes down to those facts of killing an unarmed person. But to your point about Grosskreutz, I got a sad chuckle, I guess, out of the defense argument that anybody who's got a gun deserves to be killed.
That's not what he said.
Your guy had a gun all night long. Well, anybody who points a gun deserves to be killed. Well, your guy pointed a gun at everybody that night.
Where? Where? Show me.
Sometimes I wonder how much thought they put into these arguments. Like, do you see the contradiction here? Do you see the
Show me where, you stupid attorney. Binger, you slimeball. Where did he point the gun at anybody? Other than your fuzzy picture, zoomed in picture where, again, it's make-believe. But and it's been disproven like 1,000 different ways. By video experts, they prove it. So, where else do you see video evidence of him pointing the gun at somebody he does not shoot, or at least shoot at? Yellow Pants Man? You said, you're the one that pointed the gun at me and had that laser sight on it. He didn't have a laser sight on his gun.
Hypocrisy. And there's clearly a set of rules and standards that apply to the defendant, that no one else gets to claim self-defense. No one else gets to arm themselves. No one else gets to point a gun. No one else gets to even grab a chain or use their boots or use a skateboard. All these are scary, scary people. But the 17-year-old running around with an assault rifle is privileged and an angel, and none of these standards apply to him. So that's unfortunate. But like I said, I think Grosskreutz, the jury had to hear from him. If they hadn't, it would have left questions in their mind that I couldn't afford to leave, and I wanted them to hear from the victim. And I think one of the strongest and most poignant parts of his testimony was him explaining that he's standing over someone that he knows has just killed people. Grosskreutz has his own gun in his own hand, and in my mind is legally justified in pointing it and killing this person. And he says, I'm not the kind of person that could take a life. And there are people out there that can make that decision and make it casually, but a lot of people can't.
Now the question is, how did Kyle know if he would have been able to pull that trigger? How does Kyle know that? Why is it unreasonable for Kyle not to know what is going on in Gage's mind? The Gage is really just a wimp that shouldn't be carrying a gun. Illegally carrying a gun at that time, actually. Kyle was legally carrying a gun, it turns out. Gage was not.
Clearly we know which side he's on.
Right, and of course, you as a prosecutor, you represent us, the people, and your job is to get the facts out there the best you can. You're in the truth-finding business, and your job is to get the facts out the best you can and present your case, and it's up to the jury to make that determination. You've decided here not to appeal. There's not going to be an appeal of this, or is
it's not possible. On a not guilty verdict, the state has no right to an appeal.
Okay, so that's over. Now, I understand that Rittenhouse was on I think what's been described as a right-wing news program yesterday, and he refers to you. He says he wants to become a lawyer so that he can go up against prosecutors like Thomas Binger, and uses a derogatory term that I'm not going to use.
No,
what
come
do you think
on.
of that?
I honestly haven't paid any attention to Mr. Rittenhouse since this trial has been over. I've moved on with my life. I have my own life. I have other cases. I was in trial all day today on a sexual assault trial, which is going to wrap up tomorrow. So I have other things that I'm focusing on.
Right.
I continue to get emails from time to time. They've slowed down to a trickle, but I still get emails from kind people out there that share their deepest thoughts with me in the sweetest, most gentle terms possible. Yes, I'm being very sarcastic, and I largely ignore them. I I don't understand why the focus is on me. I am not any different than 10,000 other prosecutors out there around our country. I'm doing my job just like everyone else. I am no more special, no more talented, no more unique than any other prosecutor out there. And if this case had fallen on the caseload of one of those other 9,999 prosecutors, they would have done the same thing I did and probably better than I did.
Yes.
So this was never about me, and there's no.
Out of those 9,999 other prosecutors, I wonder how many of them would have actually brought this case. Maybe 900 of them. I doubt you're going to get all 10,000 prosecutors across this nation charging this case. Hell, my local prosecutor here won't even prosecute real solid cases. So it's questionable, but 10,000 prosecutors across this nation, how many of them would have brought these charges to full trial?
Need to focus on me.
And you are the focus because you committed malpractice. You and your partner in crime committed horrible malpractice repeatedly throughout this trial, Mr. Binger. Your theory of this case is horrible, but I can understand, we can differ on our opinions. But how you behaved during this trial is exactly what I don't want to see out of my government officials. It's what I expect to see out of defense attorneys. It's what I expect to see on shows like Better Call Saul or whatever the hell his name is. That's exactly what I expect to see on shows like that. It's exactly what I expect to see out of attorneys on TV shows about mobsters. But that is not how I expect my prosecutors to act. Things you did during this trial were horrendous. The things you tried to pull were horrible. That is why you are the focus of my ire. It is not only because you went after Kyle. If you had tried this honestly and truly, without all these games, without all this malpractice, I would have never mentioned your name again. But you did.
This isn't personal. It's a job that I do. I believe that we had a case. I believe that this was wrong. I believe there should have been justice and consequences. The jury disagreed, and that's the beauty of our system. We give it to the power to the jury, and they make their decision. And once that's done, we have to accept it and move on with our lives. And that's what I'm doing. Mr. Rittenhouse can say what he wants to say. I'm not going to pay any attention to it.
Well, as attorneys, I think we understand that you're doing your job, and attorneys have to provide representation. This is your chosen field, and you're doing your job to the best of your ability. I don't know that the general public always completely appreciates that. We certainly at the Bar Association appreciate that. We appreciate you. I want to thank you for your service as an assistant district attorney. I want to thank you for sharing your time with us here on Miranda Warnings and giving the insights on this really fascinating case. We are very appreciative of both of those things. So I want to thank you for that, Thomas.
Well, you're welcome. Thank you, Dave, for the opportunity to speak with you, and I appreciate the discussion and the questions. And I don't know if anyone will be paying any attention or listening, but I hope somebody out there got something of value out of this.
Well, it's been very enlightening, and I know many attorneys are going to be very interested in what you have to say. And obviously, what we've been talking about is very serious and important. We do have something of a lighthearted feature on Miranda Warnings that I want to ask you about. We have something called Music, Book, or Movie, and you can tell us what takes you away from some of these serious topics that you enjoy.
Well, all three of those, and it's hard to narrow it down because I can talk all day and all night about books, music, or movies. So I'm a big movie buff. I've got older siblings who I grew up watching, 1930s and 40s film noir and the classics and Hitchcock.
All right. So you guys give me 1 second. I'm going to change over to a different screen. All right, here we are, you guys, once again. So I wanted to show you. Oh, looks like this is way off. Let me fix that. Sorry about that. Didn't notice. So this was done on Miranda Warnings. I used it with fair use. But the Miranda Warnings, it looks like, is put out by the New York State Bar Association. Join the Bar Association's 118th president, David Miranda, each week as he interviews some of the biggest names in law and politics. Each week he discusses all things legal and some that are not. You have the right to remain listening. So I did find this on Spotify. I just did a search for Miranda Warnings. You can see, though, and you can hear it in his interview questions, he's pretty biased. He sounds like it. And you can tell that by the rest of his interviews, sir. As a way to do important work for the people of New York, as well as talking about his legacy, talking about Abrams there. Again, just go through these. Tell me what you think. I think the guy's pretty biased. I think it's the same thing as any liberal going onto like Oprah to be interviewed. She's not going to ask the hard questions. This guy certainly didn't ask the hard questions. There are 1,000 questions I wish he could have asked, would have asked, but Binger probably wouldn't have come on knowing that he was going to be asked those questions. I wanted him to ask about the misconduct. He kind of talked about that one, but why didn't he talk about his Fifth Amendment rights? Why didn't he talk about putting people on the stand just to perjure themselves, knowing that they were going to perjure themselves? I don't know if you guys can really tell how great that is, but Sal and Sam were horrible witnesses and they should have never been called. But they were called by the prosecutor, and under the prosecutor's questions said, no, I did not ask anybody to be there. Plainly lying. So who's this in this picture? I mean, the things that Binger and Krause did in this trial were horrible. But, you guys, I'm going to go ahead and end that here. It's been a long day. There have been multiple guilty verdicts across the nation. I'm going to do another video on that probably tomorrow. But it's been a long day watching and working and doing other things. So, guys, thank you if you're still here. Let me know what you think in the comments below. Go check out Miranda Warnings here. I highly recommend it. It's hilarious. The reasons why Rudy Giuliani should be sanctioned. Dire humanitarian crisis at the border and reuniting separating children. Recognizing your own implicit biases. The myth of voting fraud. How Amy Coney Barrett is going to change the Supreme Court with Albany law Professor Vincent Bonvinter. I'm actually going to listen to that. Why we need a domestic terrorism law. Meet the freshman New York congressman who's Mondaire Jones. Yeah. Again, he's clearly not an unbiased reporter. I'm not an unbiased person either. I'm very biased. Let's not kid ourselves. I believe very strongly in the Second Amendment. I believe very strongly in the right to defend yourself when you feel that you are being attacked, that you are feeling great bodily harm or death. I believe very strongly in that, and so I don't think I would ever agree with these guys on most issues that truly matter to me. Some things I really don't care about, probably disagree with them on. But the core things I do agree with, yeah. Alright, you guys have a great night. Thank you.